The Federalist Papers, a series of 85 essays written by John Jay, James Madison, and Alexander Hamilton between October 1787 and May 1788, supported ratification of the Constitution and explained particular provisions in detail. On May 28, 1788, Alexander Hamilton published Federalist 78, titled The Judicial Department, defining the judicial as the least dangerous branch of the national government, and emphasized the importance of an independent judiciary with the power of judicial review. How was the Constitution structured to achieve Hamilton's vision? The Constitution divided the United States government into three branches, the legislative, executive, and judicial, and defined the powers of each branch in Articles 1, 2, and 3. Article 1 defines the legislative branch, or the Congress. Article 2 defines the executive branch, or the presidency. Article 3 defines the judicial branch, creates the Supreme Court and its jurisdiction, empowers the Congress to establish a system of inferior courts, sets lifetime appointments for judges, defines the crime of treason, and guarantees criminal jury trials. Articles 1 and 2 contain great detail mandating the qualifications for members of Congress and the President. These qualifications include citizenship of the United States, minimum age for House members, senators and President, and minimum residency in the United States. Article 3 does not set any qualifications to serve as a federal judge. Article 3, Section 1 vests judicial power in the federal courts, provides that judges are appointed for life, and prohibits Congress from decreasing the pay of judges. It reads as follows. Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall, at stated times, receive for their services a compensation which shall not be diminished during their continuance in office. The judicial selection process is not in Article 3, but is found under presidential powers in Article 2, Section 2. The President appoints judges with the advice and consent of the Senate. Article 3 does not organize the courts, set the number of Supreme Court justices, or establish trial and appellate courts. These issues are left to Congress. Article 3 does not create the office of Chief Justice. The Chief Justice is mentioned in Article 1, Section 3, mandating that he preside at a presidential impeachment trial. This implies there will be a Chief Justice, but does not directly create the office. The authority to decide a case is a court's jurisdiction. Article 3 defines federal court jurisdiction and limits federal courts to resolving actual cases or controversies. Thus, to bring a case in federal court, a party must have standing and suffered a real injury for which a court can provide a remedy. State courts have authority over nearly every type of controversy and are known as courts of general jurisdiction. In contrast, federal courts have limited jurisdiction and can only hear cases involving subjects defined by the Constitution and refined by Congress. This subject matter jurisdiction provides federal authority to decide the following types of cases: cases arising under the Constitution, laws, and treaties of the United States, called federal question jurisdiction; cases involving ambassadors, other public ministers, and consuls, called ambassador jurisdiction; cases involving navigable waters, called admiralty jurisdiction; cases in which the United States is a party, referred to by the awkward phrase, United States as a party jurisdiction; cases between two or more states, called state jurisdiction; cases between citizens of different states, called diversity jurisdiction; cases between citizens of the same state claiming land under the grants of different states, aptly named as land grants jurisdiction; cases between a state or citizens of a state and a foreign state or citizens of a foreign state, called alienage jurisdiction; cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, may start in the Supreme Court under original jurisdiction. Such cases may also start in a district court. However, the Supreme Court is given exclusive jurisdiction as the only court with authority when one state sues another. Article 3 provides that all criminal trials shall be by jury trial. The founders thought this so important that the right to a jury in a criminal case was repeated in the Sixth Amendment of the Bill of Rights. Article 3 has the only constitutionally defined crime. Treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. Treason was made constitutional, specific, not subject to change by Congress, and above politics. The British government used the charge against political foes. This was not to happen in America. The Judiciary Act of 1789 created inferior courts, and since then the system has evolved into 94 district courts, 13 circuit courts of appeal, and 9 Supreme Court justices. A case involving the listed subjects begins with a complaint in a district court, whose decisions may be appealed to a circuit court. Following a circuit court decision, a litigant may request a hearing by the Supreme Court. The Supreme Court has discretion in deciding which appeals to consider, and takes a case if at least 4 justices agree that they should. In 1803, Chief Justice John Marshall affirmed Hamilton's principle of judicial review by declaring part of the Judiciary Act of 1789 unconstitutional in the case of Marbury versus Madison, thus establishing the court as arbiter of the Constitution. In Marbury, Chief Justice Marshall declared the Constitution's supremacy over any conflicting law and elevated the judicial branch to its co-equal status. It is, emphatically, the province and duty of the judicial department to say what the law is. This set the stage for Hamilton's least dangerous branch of government to become a powerful co-equal institution. Hamilton argued the judiciary's power stemmed from its ability to interpret the law, particularly where legislation conflicted with the Constitution. What Hamilton framed as a check on legislative overreach has evolved into a tool for shaping policy beyond its original intent. The modern judiciary exercises power in ways that profoundly impact society. Lawmakers, scholars, and citizens must discuss judicial reform to ensure fair and equitable courts. Dialogue is crucial to avoid the judiciary transforming into a partisan instrument rather than the neutral safeguard Hamilton envisioned. If you found this video informative, like and subscribe to this channel for more insights on the United States Constitution. Share your thoughts in the comments below.